Hello everyone and welcome to another episode of The Law Life, bringing fun facts and information directly to your screens back at home. In this episode I'm going to share a story with all of you, a story that hopefully will help you out in the future or possibly with a situation you're going through at the moment. In the world of consumerism, where would we be without the ability to seek a service or a good whenever we wanted to, right? Things like buying a new car, getting a haircut, or even buying your morning coffee, they're all things that we're used to in our normal lives, and it'd be very difficult for us to go about our lives without being able to do these things. However, underneath the enjoyment that we get from getting a haircut or buying a new car, or like I said, simply your morning coffee, you get the stress caused by things such as having to get your car fixed, or maybe a TV's broken, you need to replace it. And in this lies a big and complex world of contracts and obligations. In everything you buy, a contract is created. In every service that you procure, a contract is created. And this is something that most people don't know or understand. So in this episode, I'm going to explain to you some small information about contracts, whilst also sharing with you a story about a situation that happened to me not so long ago. So the biggest misconception regarding contracts and contract law is that contract is always a physical document, a document that has to be signed, is there, a piece of paper right in front of you, and unfortunately, as any law student or lawyer will know, this simply isn't the case. In fact, the physical act of paying for a can of Coke, even with a 50p piece, if only they were that cheap now, or buying coffee in the morning, creates a contract between yourself and the retailer. You fill your car with fuel, contract. You pick up your morning coffee, contract. You pay for your parking, contract. And for example, when you pay for your parking in say for example with a big company, and you'll see when you enter the car park, there's a big sign next to where you're paying, or next to where you're getting your ticket, and it will tell you essentially the rules and regulations of the car park. It will tell you that if you stay over your limit, you'll be charged. It will tell you the price, and that is all part of a contract. It's giving you information, and by the physical act of choosing to park there, you're entering into a contract with the understanding that those terms now apply to you because you are meant to have read them and understood them essentially. These contracts are what, for example, allow us to return mobile phones if they're broken. If you were to open the packaging and you notice, say for example, you bought a brand new iPhone and you opened the package and you notice that the screen was cracked, or for some reason the software wasn't working, or it just simply didn't turn on, you can return it because the company that provided you that phone, for example, an iPhone would be Apple, they have not fulfilled their side of the contract. So essentially, contracts provide rights and responsibilities to consumers. So as I previously stated, the laws surrounding contract are vast and complicated. This is why today I'm going to share a personal story of mine. Hopefully understanding a personal story and actually adding legal fact into it will kind of help everyone understand it to a better degree. So about a year ago, I had an issue with my car. Now, I love my car. The issue with my car was something happened in the engine. I'm not a mechanic, I don't know everything. However, as far as I know, the oil pump failed and that caused the engine to seize and the car was essentially dead. So I found a fantastic, what I thought at the beginning was a fantastic automotive expert, or garage essentially, that specialised in fitting and replacing engines. When an engine goes bust, essentially they take your car, if they have a spare engine available, or if not, they'll source one and they'll replace the car, and they were doing it at a far cheaper rate than, for example, official retailers were. So about a third of the rate than if I were to go to Ford themselves, which is a car that I own. So I thought, this is brilliant. They gave me a price, they gave me a quote, everything included, including picking the car up. Everything was going swimmingly, everything was going very, very smoothly. They picked up the car, obviously I gave them the keys. Everything, for the first week, everything seemed to go very, very well. They called me about a week and a half later, they told me that the engine was fixed. The engine was replaced rather. I paid a deposit at the beginning, that shows consideration on my part. So I paid a deposit at the beginning, I signed some paperwork at the beginning and at the end. However, when I received the car back, the check engine light was still on. However, it was a new engine and the car was running. However, the check engine light was on. Now, to cut a long story short, after a period of time, I called the mechanics and I explained to them the situation. I took the car back, and they told me that they need to run some additional tests. Now, what essentially happened was they ran some additional tests. They couldn't find any electrical faults, any faults at all with the engine. However, I could hear, as well as the engine light being on, I could hear the engine was slightly off. It didn't sound like my car, if that makes sense. So they actually replaced the engine one more time, and the situation persisted. So they said to me that they're going to get the electrical expert, the electrician who works now, as I was told, who works for them, which suggests he's an employee. They said that he was off on holiday. He took me to another mechanic's that had carried out the work. Now, that mechanic wanted to charge me extra on top of what the other mechanics office charged me, and I wasn't having it. I never paid it. For a specific reason, I had no contract with that third party. So essentially what happened was I was misled. I was misled to believe that the mechanics that I'd given the car to were doing the work on the car. However, I then found out that it was actually a third party who was doing it, a third party that I wasn't aware of, didn't know their name. In fact, I didn't know where my car was for the majority of the time that it was there. I found out later, because they'd outsourced most of the work. Now I was under the representation. They had represented to me that they would be fixing the electrics in the car. They had represented to me that these would be the costs, and those representations were in fact misrepresentations. Now, that's my story. Now with that, what we'll do is that we'll go over a few legal principles, a few definitions, so you can understand the issues with this story. So you can understand a few principles for yourself. If you like, write these down. I can always put them in the comments in the description, and leave any comments if you want to ask any questions. So the first, presentation to treat. Now, when you enter into a contract, the three basic elements of a contract that need to be present are an offer, acceptance, and consideration. Now, consideration has to be shown from the beginning of the contract all the way until it's carried out. It can't just be one lump of consideration. Consideration can amount to essentially money. So, if I were to give a deposit and then pay at the end of the service being finished, that shows adequate consideration. So that's consideration. Now, an invitation to treat, that applies to an advert, for example. If I post online that I have an engine for sale, that's an invitation to treat. That is not an offer. That's essentially inviting people to make me an offer. That's the same thing with shops. Shops don't actually give you offers. They provide invitations to treat. So if you go into Tesco's, for example, and they have a chocolate bar, and underneath the chocolate bar says 99 pence, that is an invitation to treat. So it's inviting me to make an offer. Now, obviously you don't go bargaining in Tesco's, for example. However, when I go to the counter and I provide 99 pence, I'm essentially offering 99p for the product. That amounts to the offer. So an invitation to treat is not an offer. That's the first principle. Now, the second principle are the requirements of a contract. Now, as I explained to you, the main ones, the most important, are offer, acceptance, and consideration. So an offer is essentially me offering you a certain amount of money or a certain exchange for a good or service that you have. So if you have an engine and I offer you £1,000 for an engine, that is me giving you an offer. Now, the moment you give me a counter offer and you say to me, £1,000 isn't good enough, 1,200 will do, my offer is now eliminated, it no longer exists, because a new offer has been placed. Does that make sense? That person is now offering to sell me their engine for 1,200. The moment I counter back and I say no, 1,100, then his offer of 1,200 ceases to exist, and only my offer of 1,100 exists. That's how counter offer works. However, the second element is acceptance. Now, acceptance has to be clear and unequivocal. So it has to be a yes. It doesn't have to be only through words or written. It can be inferred through language. In some cases, not in many, and especially not in this case. In some cases, silence can infer acceptance. However, that isn't very common. That has to be essentially a clause in the contract or a clause in the offer that states as such, and that would make silence equal acceptance. And the third is consideration. Now, consideration has to be carried out throughout the contractual process. So consideration cannot just be shown at the beginning of the contract by offering money or giving money. It has to be essentially shown throughout. So agreeing to pay a deposit or to pay in monthly installments throughout a contract is sufficient consideration. Or for example, paying a deposit on the understanding that a 10% deposit, for example, and on the understanding that the 90% that remains on the bill is to be paid after work is completed, that's also adequate consideration, as it happens in most consumer contracts. Now, let me explain misrepresentation very, very briefly to you. There are 4 types of misrepresentation. There is fraudulent misrepresentation, where the misrepresenter essentially makes a claim that he knows not to be true. However, he makes that claim anyway. So say, for example, if my car is 5 years old, and I know it's 5 years old, so I had it for 5 years. However, in an advert to sell it, I state that it's brand new, bought yesterday. That is fraudulent misrepresentation. Sorry. The second type of misrepresentation is innocent misrepresentation. This equates to essentially, before 1967 in the Misrepresentation Act, this essentially equates to all other forms of misrepresentation. But more in modern times, innocent misrepresentation essentially means if I genuinely believe that my car is 1 years old, because I've only had it for 1 year. However, I don't know its history, but I genuinely believe it's basically brand new, and I tell you as such, and that information ends up being incorrect, it's still misrepresentation, it's still grounds for rescission. However, it is only innocent misrepresentation, not fraudulent. The third is negligent misstatement. This is actually born through case law and is very similar, although not the same, as negligent misrepresentation, which was created through the Misrepresentation Act of 1967 and essentially increased the scope of being able to apply for rescission under misrepresentation. These 4 types of misrepresentation can essentially void a contract. It means that the person who's misrepresented to can essentially rescind the contract simply by informing the person who misrepresented that the contract is hereby rescinded. However, if that isn't possible, they can apply to the courts for the equitable remedy of rescission. And the equitable remedy of rescission, although there are bars to the equitable remedy of rescission, such as when restituto in integrum is no longer available, then there are bars. So that will prevent rescission from happening. Then essentially the person who bore the brunt of the misrepresentation, for lack of a better word, has to essentially deal with his losses himself. There's nothing that the legal system can do in that situation. However, the idea of rescission is that where misrepresentation is found, the courts can order the contract to be null and void, and also it will act as if that contract never existed. If I bought a car from you for £1,000 and I apply for rescission, then you receive the car back. You receive the car. Cars are a bit different, as is seen in. I will tell you which case it is. It will be right up here on the screen. Yeah. Cars are a bit different. Let's say, for example, I bought a oven off of you, and I apply for rescission. I haven't damaged the oven. The misrepresentation was carried out. Rescission would mean that I essentially give you back the oven. You give me back the exact same amount, about the exact same sum of money that I gave to you, and that's it. The contract is. We act as if the contract never happened. It ceases to exist. It never existed at all. So we go back to the exact same positions we were before any contract was signed, before anything was agreed to. a very good representation of this. Essentially, the scales of justice work perfectly in this case. So those are the few things, those are the few principles that I'm teaching you today. The rescission itself and the bars to rescission, again, that's a topic that I could spend an entire video talking about. And the 4 types of misrepresentation, including the case law, which I'm going to put here again on this one, and the Misrepresentation Act, which is going to be also here, I will make another video talking about those specifically. Those 4 types of misrepresentation can take a 20-minute video, so I will do another video of those if anyone is interested. If you're not, tell me, but I will make one of those videos. And I can also make a separate video on the requirements of a contract, because there are other things that I haven't touched upon. What we'll do is that we'll make 2 or 3 separate videos on contracts and misrepresentation, and then you can learn as much as you possibly want about that subject. Anything you'd like to know, again, write it in the comments. I can make a video on it, or I can reply right there and then. Again, I want to make sure that everyone understands that any advice that I give on this subject or on anything on this channel is not legal advice, guys. It's not legal advice. I cannot give you legal advice. You're not my client. I've told my story, and unfortunately this does happen to all of us, or it may happen to all of us. Things like this do happen all the time, guys. So the more knowledge that we arm ourselves with, the better we'll be prepared for when it does happen, and hopefully it doesn't, but you never know. So please remember that I'm just speaking about personal experiences, giving as much relevant information as I possibly can to entertain you and to teach you all. So I would like to say thank you all for watching. Make sure that you like and subscribe for watching. Make sure that you like and subscribe. Leave a comment if you'd like to know anything else. Give a thumbs up so we know that you've enjoyed the video, we know that you've learned something, and we know what we can do better next time. Any feedback is really, really appreciated. So that's my story, everyone. Thank you for listening today. This has been another episode of The Law Life, and I'll see you all next time. It's been an absolute pleasure. Bye bye.